Hi, it's Musharraf Hussain with the subject of interpreting taxing statutes. Our today's topic is judicial system in India. India follows a federal system of central and state governments, but the constitution provides a single integrated system of courts for union and state to administer both central and state laws. Indian judicial system is a blend of court of law and quasi-judicial bodies structured in three tiers, that is Supreme Court, High Court and district and subordinate courts including tribunals and quasi-judicial bodies. Supreme Court. Supreme Court of India, established under Article 124 of the Constitution with judges being appointed by the President, is the apex judicial body in India with its seat at Delhi. It is bestowed with original, appellate and advisory jurisdiction. Its jurisdiction extends throughout the territory of India. It also enjoys the prerogative, the inherent power of writs and plenary, unlimited power of a special leave. Article 131 of the Constitution confers original jurisdiction to the Supreme Court to decide dispute involving question of law or facts between union and states or between states inter se. Appellate jurisdiction against any judgment or order of any High Court in India in respect of constitutional, civil and criminal matters is vested in the Supreme Court under Article 132, 133 and 134 respectively. The Supreme Court also enjoys a special advisory jurisdiction by virtue of Article 143, which empowers the President of India to consult the Supreme Court on any question of public importance, whether of law or fact. The prerogative power of the court as the fountain of justice of issuing writs has been statutorily recognized under Article 32 of the Constitution. So, a writ may be issued for Habeaus corpus, that is, ordering release of person, mandamus, that is, issuing directions, prohibition, that is, prohibiting to act, certiorari, quashing of order, and warranto, questioning the authority, that is, by what authority a person has come to that position. Corollary to the prerogative power is the power of judicial review of any enactment by the legislature or any action of the executive on the touchstone of the constitutional principles. So, the Supreme Court may examine the legislatures, the acts passed by the legislature, and whether it conforms to the constitutional norms and principles and the rights given thereunder. This enables Supreme Court to act as the custodian and protector of the Constitution, including the fundamental rights guaranteed therein, popularly known as Sentinel on QY, as held in State of Madras vs. V0, AIR 1952 SC, page 196. Article 136 of the Constitution confers upon the Supreme Court plenary appellate powers which are exercisable outside the purview of ordinary law to meet the pressing demands of justice. Plenary power here implies power in absolute terms which is not riddled with any statutory or constitutional limitations other than the judicially evolved self-imposed restrictions of the court. This article bestows discretionary power to entertain appeal against any judgment or order made by any court or tribunals in India and is not to be confused with the ordinary appellate power under Article 132, 133 and 134. The power conferred under this article is residuary, extraordinary and uninhibited in its amplitude, and is exercised sparingly in order to meet the ends of justice. High Court for each state established under Article 214, with judges being appointed by the President. At the state level, the High Court functions as the topmost judicial forum and enjoys original appellate and supervisory jurisdiction. Article 227 empowers High Court to exercise superintendence of all courts and tribunals within its territorial jurisdiction. This territorial jurisdiction is coterminous with the territory of a state of which it is a High Court, except the ones dealing with armed forces. Presidency High Courts. The High Courts of Bombay, Madras and Calcutta was created by British with territorial original side jurisdiction. In other words, a case which arose within the original side territory could be directly filed in the High Court without approaching the district court, and so for that territory the High Court would be the court of first instance. Since most British commercial interests in the presidency towns were located within those areas which were designated as original side, for quicker resolution of commercial disputes of the cases related with such interest were allowed to bypass the district courts and go directly to the High Court, which also had the more commercially savvy judges. Later patent appeal. LPA is an appeal by a petitioner against a decision of a single judge to another bench of the same court. It was a remedy provided when High Courts were first created in India in 1865 through later patents. It happens that the decision of single judge may go wrong because of manipulated facts or law. So before going to the Supreme Court, the petitioner has the option to move to another bench of the same High Court who is having more than one judge. Normally, a judgment and order passed under Article 226 of the Constitution is appellable as LPA, and judgment and order passed under Article 227 is not appellable under this category. However, relevant High Court rules and later patents must be consulted for details. Constitutional duty of enforcement and protection of fundamental rights by the High Court within its territorial jurisdiction through issuance of writs is embodied in Article 226, which also includes within its ambit power of judicial review of the High Court, whereby the High Court is inter alia empowered to declare a law unconstitutional. So, while Article 32 is limited to fundamental rights, Part 3 of the Constitution, Article 226 is wider and is applicable to all the legal rights contained in the Constitution, including the fundamental rights. Court of Records. Supreme Court under Article 129 and High Courts under Article 215 are courts of record. A court that is required to keep a record of its proceedings, a spoken word, and all that has taken place is known as court of record. Other courts may and upon occasion must be a record, but the records are not irrefragable, that is, irrefutable or incontestable or indisputable or incontrovertible. The distinction that is drawn between courts of record and courts not of record takes us back to early times when the king asserts that his own word and all that has taken place in his person is incontestable. It is a testimony as to all that is done before it is conclusive. A court of record being such a high and supereminent authority that it is privileged to fine and imprison people for its contempt. District courts established under Article 233 with judges appointed by the governor is within the jurisdiction of a state. Similarly, courts subordinate to district courts established under Article 234 with judges appointed by the governor is also within the jurisdiction of the state. Administrative tribunals established under Article 323A with members appointed by the President for adjudication of service matters. Other tribunals established under Article 323B with members appointed by the appropriate government for adjudication of matters in respect of tax, foreign exchange, import and export, industrial and labor disputes, land acquisition and compensation, ceiling on urban property, elections, essential commodities, rent control and tenancy regulation. Quasi-judicial bodies established under specific statutes such as National Human Rights Commission under Protection of Human Rights Act 1993 or Central Information Commission under Rights to Information Act 2005. Income Tax Appellate Tribunal was set up on 25th January 1941. The first tribunal in India established under ITAT Act 1922. Rather, it was the first tribunal in the sense that there was no tribunal before it in India. At present, ITAT Act 1961 Section 252 to 255 governs provisions with respect to Income Tax Appellate Tribunal. It is the second appellate authority, first being the CIT appeal under the direct taxes and the first independent forum in its appellate hierarchy. CIT appeal, you may see that it is under the Department of Tax only, but the ITAT, Income Tax Appellate Tribunal, is administratively works under Department of Legal Affairs under the judicial superintendence of the Territorial High Court, as held in ITAT versus V.K. Agarwal 1999, Volume 1, SCC, page 16. The orders passed by ITAT can be subjected to appellate challenge on substantial question of law before the respective high courts. SISTAT was constituted on 11 October 1982 under Article 323B of the Constitution and Section 129 of the Custom Act 1962. It was created to provide as an independent forum to hear the appeals against orders passed by the Commissioners of Customs, Central Excise and Service Tax. It is also empowered to hear the appeals against orders passed by the designated authority in anti-dumping duties. It also hears appeal concerning custom house agent clearing, licensing. The order passed by SISTAT can be subjected to appellate challenge on substantial question of law before the respective High Court. Now, after going through all kinds of courts, tribunals and quasi-judicial bodies, we come to the last leg, that is GST Appellate Tribunal. That is still to see the light of the day, because the Madras High Court, through its judgment dated 20 September 2019, in the case of Revenue Bar Association versus Union of India, has struck down the provision of appointment of members of GST Appellate Tribunal under CGST Act as unconstitutional. The government though has issued the CGST 9th Removal of Difficulties Order 2019 dated 3rd December 2019, relaxing time limit for filing of appeal before GST Appellate Tribunal, but the solution lies in early constitution of GST benches removing the legal defects. Thank you.